everybody. We are back today and we're going to be doing a more deep dive into our NAR Code of Ethics with Mr. Brett Woodburn. How are you today, Brett?
Doing well, Nick. How are you?
I am here. I'm in severe pain still. So gotta
Self-inflicted or?
partially, I guess you could say. It's hard to say anymore. How is Miss Heather out there in Philly?
I'm all good. I'm all good in the hood.
Nice.
Can't
So as you
complain.
guys have noticed, we've been using some new systems. We've done some major upgrades. We are now doing, one-off cameras. So, leave some comments if you guys are enjoying having some more technology involved that's getting, a little bit better and with audio and video and all that fun stuff as we continue to grow. And we have people looking into it. So, but diving in today, we are looking at Article 3. It's the article that we are on for the Code of Ethics. So, Brett, what would you say is one of the main points that you would want to draw attention to on Article 3?
The timing for reviewing Article 3 is really spot on because Article 3 is one of the most affected or impacted articles coming out of these new changes to the way we practice, right, in real estate. Article 3 is really the obligation to cooperate. And based on what I've seen over the last, let's say, 5 months, and how realtors have responded and reacted to the changes imposed by the NAR settlement, reacting and adjusting or not to removing offers of compensation from the MLS, I think it is important for realtors to reacquaint themselves to what Article 3 says. And I mean, I think just to kind of take a half a step back, I think, to be a professional realtor, and we've talked before, and I often talk about the distinction between being just a real estate licensee versus the choice, the conscious business choice to become a realtor and all that entails. And one of the chief distinctions is the Code of Ethics. And oftentimes I suggest to people that you should be reading the 17 articles at least once, if not twice a year at a minimum, not necessarily all the standards of practice. But I think it's good because it's a reminder, a healthy reminder for you as realtors as to what the obligations are that set you apart. And as I've had some recent discussions, a licensee, a real estate licensee, can 100% act unethically, but legally. So the Code of Ethics, you're affirmatively holding yourself to a higher standard. And Article 3 is the duty to cooperate. The obligations under Article 3 have been incorporated into, I think, all of the MLSs in Pennsylvania, at least those that are realtor owned. And I think even West Penn Multilist, which is not realtor owned, has incorporated most, if not all, of the expectations of Article 3. And then across the country, of course, if you're a realtor owned MLS, one of the fundamental rule changes that came out of the settlement was redefining within the MLS cooperation and making crystal clear that cooperation has absolutely nothing to do with compensation. And so right now, I think this is a great time, an important time even for realtors that are trying to figure out their way and how their practices are going to evolve to reacquaint themselves with Article 3. It's an agency specific, in Pennsylvania. One of the mandates that you have this year for your continuing education is agency. And Article 3 is one of the articles under the Code of Ethics that really talks about some of the duties that realtors have relative to agency.
Yeah. And I would say, so, that being one of the required CEs, if anybody is going out to triple play, there is a class already there that you guys can get that required CE done while you are at triple play.
Hey, if you're locally next, what day is today? Wednesday?
I don't know.
Yeah, the 2nd?
It's a day.
Yeah. A week from today, the 9th, I'm actually teaching an agency course at Greater Harrisburg Association of Realtors on agency, and it is satisfying the requirements under the licensing aspect of it. So,
I wonder if the last one I took with you technically falls in the CE period or
it
that
fell
CE.
outside of the CE period, I think.
Okay. I was like, well, then shit, I already have mine.
Yeah. Yeah.
So when you're looking at this, so what I'm hearing from you is that the understanding of this used to be that cooperation included compensation, and it never did. And it's now just making this more apparent to individuals that we are to cooperate with each other with what exactly?
So the concept of cooperation and compensation were never conjoined in the articles. It was never an ethical obligation. Compensation and cooperation were more closely tied together under the MLS rules.
Mm.
And so when go back 5 years, 6 years, when the lawsuits came to a head, um, they attacked the conflation of compensation and cooperation that went through the MLS. The idea of cooperating, in Article 3, it obligates realtors acting particularly as listing agents to cooperate with other agents, other realtors who are looking to sell the property, unless it's not within the client's best interest. And cooperation means, and generically, providing access to the property, providing timely responses to inquiries about the property. If you have offers
Not
being submitted,
misrepresenting access.
not misrepresenting access. I think that I've seen it drawn into artificially, creating an artificial sense of urgency. The responses, the presenting of offers, counter offers, access to properties for inspections, providing information necessary. If you've got a commercial property, because again, if you're a realtor, the articles do apply to you. If you've got information that's needed in order to facilitate the sale of the property. And I think it's also important to understand, unless it's not in the client's best interest, and I think that word client needs to be highlighted, bolded, italicized, flashing lights around it, because it's really what is in the client's best interest, not in what the realtor thinks is the client's best interest. There's a tie in with Article 3 and clear cooperation. And because again, cooperating, right in the clear cooperation policy, which is an MLS policy, is the word cooperation, which ties back to Article 3, and it all comes together nicely and neatly. When you talk about, siloing information, when you talk about doing office exclusive information, and you're, as the agent, you are framing the value of an office exclusive, which is not cooperating. It is the antithesis of cooperation if you're holding it internally. So I think, Heather, to your point, the misrepresentation of that, when is it not in a client's best interest to cooperate? I mean, very, very few instances. I mean, a couple that come immediately to mind is someone that's in law enforcement, for example, a judge, an undercover police officer, a federal agent, that making their information, their home address available through the multiple listing system or services or the other platforms, is an area where you've got to be careful. There is an expectation or a need for privacy. If you've got somebody that is a victim of domestic violence and there's a sale as a result of that, if you have, and this isn't really something that we have in Harrisburg, I don't think, to the level that makes sense. But if you have a celebrity, Philadelphia and Pittsburgh are two areas that would have celebrities, whether sports celebrities or media. I mean, Michael Keaton from Beetlejuice is from Pittsburgh and still resides or has homes in the Pittsburgh area. Those are the types of instances where you don't want people just to wander through a house. I mean, Heather, in your area, you got a practice out there using the buyer financial information where there's an expectation, or in some instances a requirement, that a buyer identify their financials before giving access to show a property. If you would even raise that as a specter of a whiff of a conversation in Pittsburgh, you might need 911 services, because it's none of your damn business what's in my wallet or my bank account. How dare you ask? So,
right. And I would say that that's kind of the same feeling here in the Harrisburg, the greater Harrisburg area. That form does not get used very often either. And it was shocking to me when, working with Heather on stuff, when I found out that that is something that they use out there, and it's actually not a horrible form. I do like that, especially on the listing side, but then I also see the buyer side of it, of where some of it's truly not. Yeah.
Yeah, and I mean, Brett, when you say like out in my area, I've pushed back on it a couple times because a lot of agents feel that it's a mandatory form, that there's some sort of mandate, and I explained to them there's not, and I explained to my clients the same thing. And I have agents who ask for that form, who say, well, where is it? I can't present the offer. And then we have to have a little educational chat about that. I said, is that a counter offer from the seller requesting it?
Yeah, you're 100% correct. I've heard it said. I do have some clients that are in Southeast Pennsylvania, and I've heard it said that, well, we won't even do a showing unless we have the BFI.
Yeah.
Okay, as a generic statement that sometimes prompts me to ask some follow-up questions. Why is that? Is that a conversation that you had with the seller, that the seller is understanding and affirmatively recognizing what that means, or is that you being a real estate licensee who thinks you know best for your seller and imposing your business model, your business practices, or your bad training, as the case may be, into the transaction? And I think those, and you're right, Nick, the form does have value in certain transactions. And I think that there's going to be different uses, valuable uses for that information, depending on how your practices evolve in different marketplaces. I think you're going to see, for example, as practice changes and, again, emphasizing the cooperating and compensating are unrelated.
Yeah.
They're distinct from one another. If as practice in certain areas shifts away from listing brokers offering compensation, buyers brokers and buyers agents buyers coming in and making different offers, and perhaps to strengthen an offer, maybe you've got a buyer that's in a financial position that they're not asking for any type of concession from the seller, any compensation from the seller. Now we might have a seller that's going to say, well, look, can you at least verify, give me some information to show that your buyer has the financial wherewithal to close this deal. I mean, now we're looking at a situation where you need to bring $20,000, $30,000 to closing.
Or they're getting a gift.
Or they're getting a gift. Or, yeah, there are a number of reasons where that may become a more acceptable practice in other areas as the dynamics are changing. So, yeah, and I think it's a solid form. There is, particularly when you get into the higher price points,
Yeah.
there's a lot of value for it.
I had a very unique property. Heather actually ended up being with me when I went to do photos for that property. And the sellers were up front. They didn't want just anybody wandering around their property. It's it's 12 acres and some change. $700,000 listing, $750,000 listing, and they didn't just want anybody wandering around their property. Let alone the pull and the liabilities there. So in their case, they just asked that everybody submit their pre-approval ahead of time. Just send your pre-approval over so that we at least know what you're looking at, you can afford to buy. And then they did actually also limit people bringing their kids to the property, only because of the pull and the openness of it. They were very fearful that, just walking around, if people were to get a little rambunctious or not be paying attention, someone could fall in. Gorgeous property. But they were very, very honest and upfront with a lot of people, like, limit the number of people that are coming to the showing, this, that, and the other, just because of what could have potentially happened.
Yeah.
Right.
Yeah.
So
I have a client that has an 8-figure listing in a residential property, and very particular. And it's someone who is very security conscious, security minded about people having access. So there are a number of times where, and again, that falls under Article 3. It's not in the best interest of the client just to let anyone into the property.
Right.
Correct.
And not only restricting who has access to the property, but also asking very pointed questions about, I bet this property is listed for $32.6 million. Do you have, I want to see your bank account. Do you have $1,500 in the bank account? And we're not letting you in.
Yeah.
And again, those again, what really comes back, and I think it bears repeating and reminding to realtors that the driving decision maker behind this has to be the seller, the client.
Correct.
On this, and I think you're both members of Bright, and I'm aware that Bright has recently, used the word recently loosely, modified their clear cooperation policy, but the acknowledgement that the seller is asked to sign. I actually heard, I was recently, Nick, you're aware, I'm not sure you are, Heather, but last week, I think it was last week. Yeah, last week I was out in Seattle at an industry conference, CMLS, and heard one of the speakers or someone speaking in there that challenging Bright's acknowledgement form as being threatening the sellers into agreeing to cooperate and agreeing to make the property available. And the response was no, hang on, it's not a threat to the sellers. It's not a statement telling them that they're an idiot for not
Doing
cooperate.
this.
And really phrased the argument really was, you're interfering with my ability to do pocket listings, or
Basically,
I'm sorry,
Right.
agency exclusives. Freudian slip of the tongue, or maybe not so Freudian, maybe not a slip. Anyway, and the response was, hang on, no, this is ensuring from the perspective of Bright MLS and other realtors that this really is the seller's knowing, informed,
Decision.
and specific decision.
Yeah.
And then I saw the form, and I like the form. I think it's, as an attorney, understanding the importance of who drives the decision making, and understanding the reality of your industry, and realtors, and how so many consumers are looking for you to advise and guide and help them through the process, becomes very easy, not unlike being an attorney sometimes, becomes very easy to impose my decision-making process on the client. And it's, I've learned it over many years not to do that. That form that Bright has relative to office exclusives, I think is a very solid form. And I think it's very beneficial under the concepts even of Article 3. And in particular, to bring this back to Article 3, because it is reinforcing the agent's obligation, not just agent, because Bright doesn't have an exclusivity requirement, but a realtor's obligation to cooperate.
Yeah. The other thing that I would add to that, though, too, is, and, perfect example was, I was doing a listing appointment Monday night, and we were going over all the forms. And when I got to this one, I said, this is just furthering the transparency of why you guys have decided to work with me. And I went down the form with them. We were already, before we even got to that form, it was going on the market. We were doing what I feel is truly best. And then that form just basically reconfirmed what I told them. And again, I think I told this to Heather. I think I even told this to you. I won that listing against an agent that actually does outperform me in that market. I'm not real big in the York County market yet. We're growing there for sure, but I won that listing against that other agent because of my transparency and letting the seller know all of their options. And truly, then you drive that bus. And that's what I always say. You drive that bus. I'm just sitting in the back screaming and waiting to get yelled at, basically.
And really, one of the primary questions that a seller wants to be asked and to answer for an agent is your goal to get this property in front of as many people as possible so you can have the widest pool of potential buyers to sell the property as quickly as possible to net you the highest dollar amount. All right. Notice I didn't say get you the highest purchase price, because the seller really doesn't care about the purchase price. The seller cares about the net. And if their goal is to get the highest net as quickly as possible, and they're in a price point where the best way to ensure that or create a system where that's going to happen is to get the widest pool of potential buyers, then the question for the seller is, then why don't you want it on the MLS? Well, I want it on Zillow, I want it on realtor.com, I want it on yahoo.com. Okay, then why don't we want to triple that or double that or whatever the percentage increase is, and put it in the MLS, because now we're reaching so many more people that may not be searching those areas. And maybe they have a valid reason, maybe they have an emotional reason, but the reason being theirs, as long as it's their decision to do that.
Right. So question for you, because 3.9 and standards of practice 3.9 and standards of practice 116 have always had me in a little bit of, sounds a little like we're doubling up on it, but maybe not. What are your thoughts?
So 3.9 it says realtors shall not provide access to listed properties on terms other than those established by the owner or the seller.
Right.
All right. So
and 116 says realtors shall not access or use or permit or enable others to access or use listed or managed properties on terms or conditions other than those authorized by the owner or seller.
So they're parallel, right? Article 1 is the obligation that you have to your seller, do what's in the work for your seller's best interest. Article 3 is the obligation.
Too. That's a big difference. Use.
Correct.
Use is in 1, not in 3.
Correct. But they run parallel, and I think to some extent you're right. But let's talk about what that means. It to some extent, it's what we just talked about. I'm a billionaire, and I've got a property, and I don't want people wandering through. I'm a sports celebrity, and I don't want people just coming through my house because they're a fan. I'm a undercover DEA or U.S. Marshal. I got to be careful about disclosing my address. Let me throw another kind of curveball at you. As a listing agent, when you're talking to your seller, are you asking them if they're okay if some person you don't know who might have a real estate license but doesn't have any type of relationship with a prospective buyer, you're authorizing me to hang your key on the front door, and do you want anybody to walk through your house regardless of who they might be and who might be opening the door? Or do you want to control access to the house and say, I'm not interested in tire kickers. And if you're not working with a real estate agent, to me, you're not serious, and I don't want access to the property. Or I want to require you to I only want buyers to come into my property that have some level of representation, whether it's with a real estate agent or an attorney, or they're going to contact, otherwise, if they contact you directly, and they want you to show the property, Nick, you're my listing agent, and they want you to show the property. And of course you then you're going to be there, or someone from your team or your office is going to be there to show the property. You're not giving them unfettered access to the house. That's another way that under Article 3 that a seller can control access to the property. You're not just opening. So it does require, I think they work together, Heather. I think they provide a lot more opportunities for realtors to exhibit their level of professionalism and commitment to their client, whether it be a listing agent is saying, I want to, this is some things you need to you're allowing and inviting strangers to walk through your house.
Right.
And as part of that process, you're taking the dog, the cat, the kids, and you're leaving. But all of your personal stuff is still there. All of your photographs, your wedding albums, your pots, your pans, all of those things are in the house for people to poke through your drawers and see what's there, opening the cabinets and that. Are you okay with anybody walking through? The flip side, if you're a buyer's representative, look.
I was just going to say that.
Yeah, here's an opportunity for me to, and this is what I can do for you to ensure that you have the opportunity to see, so two different ways, two articles that I think run in parallel and in concert with one another. I think, Heather, that those are, again, you want to read the articles and the articles together, but the standards of practice are the official adaptations of the National Association of Realtors as to how the articles are to be applied. I think that again, we're in an interesting market right now, an interesting time within the industry, and the Code of Ethics sets you apart from non-realtor licensees. But here's another opportunity to demonstrate your level of professionalism over and above what a just a simple real estate agent might offer.
So we're really looking at the listing side of it with the
Hmm.
cooperation right now. What would you say is the buyer agent's responsibility in this instance? So, perfect example. Obviously, things have changed greatly. So, this would be, I think we can figure out how to word this for the new way of doing things. But let's say I get a call into the office that somebody drove by 123 Main Street and really wants to see it.
Mm-hmm.
And I do, at that point in time, what is my responsibility to make sure that I'm living up to our code of ethics number 3?
As a listing agent or a selling agent?
As a selling agent.
I think that your obligation, first of all, you've got the new MLS rules that require a written agreement of some nature. And whatever that might be, you've got different options available as to what that type of relationship is going to be. But I think under Article 3, you have a duty to cooperate. It's often more viewed from the listing agent side as far as access. But I think that the being forthright as to when you're going to be there, as to being respectful of the time, any time limits or expectations set by the seller. I think that providing honest feedback
Hmm.
to the listing agent.
There we go.
I like
that
yeah.
one.
Now wait a second though.
There's honest feedback and there's Nick's honest feedback. And
yeah, but let's have a conversation about that, because there are some buyers agents out there right now who are not giving feedback for fear of giving feedback, but then putting their client in jeopardy with either negotiations or what they said, etc.
well,
So
all of this, again, your obligations of your obligations of real estate licensee are further enhanced by your duties under the articles as a realtor, are tempered by your professionalism and the advice you give to your client.
mhm.
So the realtor that just writes down the place stunk of mold, but then they want to submit an offer.
Right.
All right, let's stop and think about that a little bit. So the Code of Ethics requires honesty. It doesn't require fairness. On the buyer side, there's no affirmative obligation to give feedback. You don't have a duty to tell the seller what you thought of their house.
Okay.
And for the points that you pointed out, Heather, there might be a lot of reasons why not to do that. But there may be a reason with your buyer that wants to say something that says, hey, I remember years ago when I was looking for a house and I walked into a property, and within 30 seconds I said to the listing agent, let's go. We're out. And he said, why? I said, all I smell is cat urine.
Yep.
It was an assault, and he didn't notice it. I think he had a cat, so he was kind of nose blind to the smell.
Yep.
And he said, well, what do you want me to tell the listing agent? I said, feel free to tell them that was my feedback, because if you have someone like me that really is sensitive to that odor of ammonia. And interestingly, in that, as that turned out, the listing agent was very appreciative of the response. The sellers took immediate steps to rectify that and from their perspective, resolve the smell, which they may or may not have done. They invited us to come back and to see the house again, but wasn't interested at that point for me. But they were appreciative of the feedback. So there may be times, even when your buyer's not interested in the property for any number of reasons, why feedback. But don't give feedback just to poke at people. I mean, that's a different type of cooperation.
Correct. And, so that's the perfect example that leads into the statement I was going to make. At the end of each showing, the questions that come from showing time to me later, I literally have them wrote down. I just ask my buyers, what are your thoughts? what's this, 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 and this.
Mm-hmm.
They give me their answers, and then I say, do you want me to share this with the listing agent? Yes, no.
Mm-hmm.
If they say no, obviously I'm going to do as they've asked. If they say yes, obviously I'm going to do as they've asked. But there are individuals, and I've heard them even brag about it, that, you know, that they've went through a house and it was awful, and they left a horrible review to the, you know, feedback to the agent about, you know, it just basically had lipstick on a pig and this, that, and the other. And it's like, why were you like, what is the point of being nasty?
Well,
Like,
there's another component to that, and I think you find it in 3-11, standard practice 3-11, and that's there's a fair housing aspect to this as well.
We're going to talk about that topic again this week.
Oh, jeez.
Well, yeah, but you know, to your point, and if you stop and think, a few years ago, there was and it was out of Marin County, California. It made national news. Was the fair housing claim brought against a particular appraiser? And the circumstance of that was, you know, over the value of a home that was in Marin County, which is an affluent county in Southern California. From what I read, I'm not familiar with it myself, but over, you know, having purchased the property in 2016, and then refinancing in 2019, refinancing again in the pandemic, the value certainly has not gone down. And then they in 2000 and maybe it was 22 or 23, they went to do a refinance to do some renovation work. And an appraiser came in, and the price had gone from, I'm going to just kind of pick arbitrary numbers, so don't fact check me on this because I don't remember. But let's say it was valued at 1.1 million in 2020. And then in 2022, the appraiser came out at, you know, $875,000. Was a black family, African American family. They called a different appraiser company, and they went and took out every photograph, picture, music album, article of clothing, hair product that suggested that they were black, and then asked their next door neighbor, who was white, to meet the appraiser. And they had a different appraiser, and the property came in and appraised at just around 1.2. So you had almost a crazy high, almost a 30% difference in valuation. Okay, so
I remember hearing about this now.
So, you know, let's go back to your reference to the, you know, people, you know, so it's sticking lipstick on a pig. I get the reference generically, but then my question becomes, why? You know, why are you saying that? And if you go into a house and for whatever reason the house you know, indicates that the owners are of a particular race or religion or ethnic background, or you know, same-sex couple, or any of the protected classes recognized either in Pennsylvania or under the Code of Ethics, because the Code of Ethics has a broader interpretation.
Yeah.
And that's the reason you're not going to put an offer in on the house. That's the reason you want to leave a negative feedback.
Right.
I mean, I could see it if it was, you know, Baltimore Ravens paraphernalia all over the place. I mean, that should be, you know, No, I just kidding. Sort of, not really. I was a Steelers fan, but again, you know, cooperation. You know, people don't think about Article 10. You know, being the fair housing article, but there's other components and other aspects in the cooperation. You know, I won't show you a house because I won't show your clients the house because
I won't let the agent.
Yep, I won't write an offer. I won't put an offer in this house because you know, cooperation. Article 3 is more routinely applied and considered from the listing side of it, but it's not inapplicable to the buyer side as well.
Well, so while we're talking about the whole statement there about like, oh, I won't write an offer on this house because it's with this person. Obviously, fully unethical. If your client wants to write it, you write it. What would you say the obligation is of the agent to share past experiences that they have had or transactions with that agent that they could potentially experience in this one.
I think an agent, to some extent, um, so I guess let me start first and say, let me get your counter ready. It depends. Are your experiences would they be relevant to this transaction? So that's the first question.
Let's say the answer to that is yes.
If the answer is yes, then regardless of what side of the transaction you're on, those are things that might be valuable to your consumer, your client, whether it's a buyer or a seller, to understand, because at some
Like
point
why? What's the
you've got to
why?
accept, right, you've got to set expectations. I've worked with this agent before, and they are notoriously slow about responding. It's very, very hard to get, we've got timelines in the agreement of sale that we have to meet, or else you, the buyer, are going to be put in a difficult position. So because of that, maybe we need to extend the inspection period, the contingency period from 10 days to 15 days. Maybe we need to, hey, you're particularly concerned about some things that might show up on title. All right, we have a contingency in the agreement of sale, but we know that title right now, we called my title company, and we know that we're getting 7 to 10 days on a turnaround time. We need to extend the timelines. And, this particular agent is, again, I'm using the example of slow to return calls. We need to extend the time on that. Or, I've got I've worked with this agent before, and they're very, very curt and abrupt, and they can be very abrasive in how they're dealing with you and how they're dealing with me. And you need to let me, as your agent, be your buffer on that, and not let that type of an approach color your perspectives or shade your perspectives on the underlying transaction. So there's a lot of value. The fact that you maybe suffered a personal attack by this agent.
So this is the situation that I dealt with. I want to say it was probably in 2020. I had two houses on the same street, opposite ends. Both were definitely flip homes. Like they needed a lot. Both families just wanted to move on. My one property, I get this offer in, decent offer. Seller decides to take it. Deposit was due in 5 days. Deposit never comes. I start reaching out. What's going on? No responses. Finally call their broker. I'm not sure. I'll reach out. I get a termination in the email. After I spoke to their broker, I get a termination a few hours later in my email. I don't know if they fell down and bumped their head, but the following week they wrote on the other property on the other side of the other block, same agent, same buyer.
Okay.
And I looked at my sellers because they were two separate sellers.
Right.
I'm like, we want deposit same day if you're taking this. Like, sure. I want check.
Yeah. That's yeah, great. Here's the Venmo account, or wire transfer, or we're gonna or a contingency, right? We're gonna continue marketing until the deposit is paid.
Yeah.
Those are absolutely valid experiences to share with a consumer. And those, again, duty to cooperate doesn't mean that you have to let everybody and their brother into the house.
Right.
You are still expected to, and as a buyer, you asked earlier, how does a buyer comply or work within the expectations of a listing agent in Article 3? The better you position yourself professionally, the better you position your buyer, the better, you are the reflection, right, of your buyer. That's the only contact that the listing agent is going to have. In most instances with the buyer, at least at the beginning part of the transaction. The stronger you present yourself, the stronger you present your buyer, the more cogent the conversations are, the less reason a seller or a listing agent has to question the value or the validity. I mean, I had a client recently sold a house, and the selling it faster was important, but not the sole issue. but the value, the agent's experiences, the listing agent's experiences with the other buyer agents, or no experience whatsoever, was a question that the seller asked. Well, what do you know about the agent? Are they good to work with? Do they make it difficult? They understood enough to know that the buyer wasn't really the person that they were working with. One of the questions that the seller asked is, well, how thorough a job does this buyer agent do in vetting their buyers? Because we're looking at mortgage contingencies. This particular seller was not inclined to sell to investor unless that was the best option. They would have preferred, it was the house they were selling was a first-time home for them, and they really wanted to sell it as a first-time home. And ultimately, that's the choice that they made, and took less money, actually, a lower net, because of that decision-making process. So all of those things do come into play. And again, I had a conversation with an attorney yesterday, who said, and this is from another part of the United States, it said in the market where he operates, he's also a broker, but his sellers, in a different state, different rules, right? So they don't have they don't have a non-agency relationship permitted in their state, like we have in Pennsylvania. And we had an interesting debate about whether a non-agency relationship really is a non-agency relationship. And I agreed it's not. It's a different kind of agency relation. But and his his perspective and his agent's perspectives in his offices, I'm doing a disservice to my seller if I'm just allowing the chauffeur, the person whose sole job is to just simply go up and open the door. I don't know anything about these people. I don't know anything about who they are, what their interest level is. And he said, my comment to those agents that are saying, well, what if they won't sign an agency contract? And his response was, then they're not ready to buy. And don't waste your time with them. And then again, that's another perspective on practices. And his perspective as a listing agent counseling his sellers is, you don't have to open the door for everybody who wants to see your property. You control that, but your level of control, number one, needs to be lawful, and number two, needs to be such that I can apply it to everybody. You can't just be changing the rules on me either, and we've got to know what they are, because I have to communicate them to my colleagues who want to show the property to legitimate buyers. And what do they need to do as a buyer broker, a buyer agent, to position their buyers so that they can get in and put in and then we know we're going to have a serious offer if they make one.
So guys, as you can tell, Article 3, it's about cooperating, not compensation. Take a look at it. If you have questions, send them in to us. At the end of this series of going through the Code of Ethics, we're actually going to kind of talk through how you file a complaint and what that process looks like. And then the last one after that will probably be a Q&A based off of questions that people have sent in to us on the different articles. So don't forget to like, follow, and share.